Hi everyone. Hi everyone. Welcome to another edition of Copril Corner. Now we want to talk about the various categories of land as classified by the Land Registration Act number 3 of 2012. Now we have public land, community land, and private land. What is public land? Public land, according to the Land Registration Act number 3 of 2012, is an alienated government land at the time the Constitution came into force as laid out in the Act that was in force at the time. What do we mean by this? An alienated government land. First and foremost, an alienated land is land that has not been set aside for any particular purpose, say for agricultural purposes, for hotel purposes, for residential purposes, for commercial purposes by the government. Now, any unalienated government land that has not been set aside by the government, but this land still belongs to the government, at the time the Constitution came into force, which is from the promulgation of the Constitution of 2010, as laid out in the Act that was in force at the time. Now, before the promulgation of the Constitution, there were various acts that were in force, and these acts also classified land in form of government land, trust land, community land. Now, those acts that were in force at the time, that is what we mean by an alienated government land at the time the Constitution came into force as laid out in the Act that was in force at the time. Now, number two, all land lawfully held and used by the state. All land lawfully held, used, or occupied by any state organ except under a private lease. Now, state organs use land, they occupy land, and they hold land. Now, we have certain state corporations which have private agreements with private individuals. Now, any land that is held by a state organ under a private lease or a private arrangement by a private individual, any land that is held by the state, occupied by the state, and used by the state, except that which is under private agreement by private individuals, is declared as public land. Number three, land transferred to the state either by sale, reversion, or surrender. Now, if you sell land to the state, automatically that becomes public land. If land has to revert back to the state, automatically that becomes public land. And if one surrenders land to the state, that becomes public land. Number four, land whose legal ownership cannot be proved to be either of an individual or a community. Now, we have parcels of land that do not have any form of, there is no proof of legal ownership. Now, these types of land are, for instance, we have particular areas where we have land that has no claim at all. Now, this land automatically becomes public land, and it automatically becomes public land. Now, land whose hire cannot be established legally, as expressly as it states, land whose hire cannot be established legally is automatically public land. Now, all minerals, all government forests, all rivers, lakes, and other water bodies, territorial sea, land between high and low water marks, any other land declared public by an act of parliament, that is public land. Now, let's go to community land. What is community land? Community land is land lawfully registered in the name of group representatives. Now, if there are representatives of a certain group or of a certain community, and they own a parcel of land, and this parcel of land happens to be registered, that becomes community land, for as long as it has been registered through proper legal processes. Number 2, land lawfully transferred to a specific community by any process of law. Now, if land, say public land, has been transferred to a certain community by legal process, that becomes community land. If private land has been transferred to a community, that becomes community land. Now, any other land declared community land by an act of parliament, if parliament declares land to be community land, automatically that becomes community land. Now, land that is lawfully held and managed by specific communities, land that is ancestral land and land occupied by hunter-gatherer communities, land that is lawfully held as trust land by the county government. Now, trust land is land that is held by the county government on behalf of residents of an area. Now, that is what we call trust land. And trust land in the new constitution is classified as community land. Now, let's go to private land. What is private land? Private land is registered land held by any person under any freehold tenure. A freehold tenure is an absolute tenure. Absolute means, in layman's perspective, that you own that land without any time prescription. You own it absolutely. That is what we call freehold tenure. Now, number 2, land held by any person under leasehold tenure. Now, you can hold government land under leasehold tenure in private capacity. Now, that becomes private land, but it does not cease to become government land. And neither is it public land, since you hold it under private capacity. Now, if you have a lease from the government for, say, a period of 99 years, now that leasehold interest you hold classifies your land under private land. And if you hold a lease under a certain lessor that is not the government for a certain period of time, say 45 years, say 10 years, that becomes private land until the expiry of that lease. Now, any other land declared private under a relevant act of parliament becomes private land. I hope that sheds a little light on the categories of land as per the Land Registration Act number 3 of 2012. Now, we have said, just a recap, what categories of land do we have? Number 1, we have public land, we have community land, and we have private land. In summary, we can say public land is an alienated government land as laid out in the Constitution, an alienated government land at the time the Constitution came into force, as laid out in the Act that was in force at the time. And number 2, we say community land is land lawfully registered for as long as it's registered under group representatives, or land that is transferred to a particular community by any processes of law, or land that is declared community land by an act of parliament. That becomes community land. And number 3, we say private land is any land that is registered and it is held by any person or any individual under a freehold tenure or a leasehold tenure, and it's registered and it's held by a private individual or declared private under a relevant act of parliament. You can like our video. You can visit our page on Facebook, Copril Real Estate. You can subscribe to our YouTube channel, County Priority Investments Limited, or Copril Real Estate. Let us engage, let us discuss, let us share, and let's make 2019 a year that we have fully understood the Land Registration Act number 3.